The task force met for a little over 2 years, and we came up with 55 recommendations, and obviously we'll not have the time to go through all of those this evening. I want to touch on a couple of them that I think are some of the more interesting ones that we recommended. And then before I get into that, I want to sort of give you a sense as to why the task force was put together. Back in 1997, the American Bar Association actually called for a moratorium on death penalty executions around the United States because they had conducted a study and had a lot of concerns about the process, the procedure that was going forward in enacting executions around the United States. And so as a result of their study, and I think here's what's interesting, here are the findings that the ABA made. Okay, they found significant racial disparity, that they thought that an electoral process influenced judicial elections, that no policies for attorneys representing people with mental retardation or mental illness existed, that there was non-accredited crime labs that were involved in death penalty cases. There were no requirements for the preservation of evidence. There was no best practices for law enforcement, no policies on prosecutorial discretion, no specialized training for people that were involved in capital cases as well. Indigent defendants were being underfunded, as well as concerns about the various jury instructions that were involved. And this was back in 1997. Very little happened as a result of their call for a moratorium. So they then started another study in 2003. And what the ABA decided to do then was to look at individual states and how those individual states were conducting this. Ohio was one of the states that was looked at, the process that we were following. And again, after the conclusion of that study, there were still concerns similar to those that were expressed in 1997. So as a result of the Ohio study, there were concerns about the collection, preservation, and testing of DNA evidence. Again, law enforcement identification and interrogation issues, crime lab and medical exam offices, again, being unaccredited, prosecutorial professionalism, appeals issues, racial and ethnic minority, again, with data showing that individuals in that class, once again, were being disproportionately executed. And so after the 2003 study that was done specifically for Ohio, the hope was that there would be some changes. And actually the legislature made some minimal changes as it related to the death penalty. So it was based upon that information that the Chief Justice for the Ohio Supreme Court, as well as the President of the State Bar Association, the Ohio State Bar Association, decided to put the task force together and decided to try to get as big a cross-section of individuals in the criminal justice system, as well as educators, law enforcement, as well, for the purpose of taking a look at the recommendations and deciding which of those recommendations needed to be made for the state of Ohio. Now, one of the things that was not on the table for our discussion was whether or not to abolish the death penalty in Ohio. The specific request of the task force was that we look at what we have in place, make recommendations, and then the hope is that these recommendations go with the legislature. The report of the task force came out about April or May. I always say that the one thing that sort of bothered me the most about it, again, we put in a little over 2 years of work as it related to this. At the conclusion of our work, there was a minority report of those who objected to many of the recommendations that we made. And so the news story was all about the objections to the recommendations as opposed to the actual work that we did. So I see at least opportunities like this are opportunities for me to at least try to explain to you, and then hopefully when we get to question and answers, answering any questions that you have as it relates to what the task force did. Now, some of the information that was before us as we were considering considering the death penalty. We looked at information that indicated to us that between 1999 and 2011, in Cuyahoga County, there were 390 indictments for capital cases. In Franklin County, there were 182. In Hamilton County, there were 55. And then you get down to Summit at 38, Lucas and Stark at 32, and then Montgomery at 15. Well, the reason that this number was something that caused a lot of concern for many on the task force was that there was such a huge disparity as to what was going on in Cuyahoga County as it related to the number of indictments there versus the rest of the state. And one of the conclusions that we reached, and there was actually one of the judges on the task force, Judge Donnelly out of Cleveland, who said that it was his belief that the prosecutor was using the filing of capital indictments as a negotiating tool, and that actually they were threatening by indictment capital punishment in an effort to get the person to plead guilty to a lesser offense. And that's not the way that it should have been utilized, but that was one of the reasons for the huge disparity in Cuyahoga County. But also in looking at these numbers, there were other disparities in terms of, in certain counties, if you lived in those counties, the chances of you committing a crime and being convicted, or excuse me, being prosecuted on a capital offense was great solely because of where you lived. There were other counties where you lived, you could commit the exact same crime, and in those counties you would not be prosecuted on a capital case. And so really that accounted partly for the disparity in terms of the number of ethnic individuals being prosecuted and ending up on death row, because most of the urban areas were the ones that would do so, would engage in the filing of the indictment. So one of the first recommendations that we made with respect to the task force was with regard to interrogations. You know, many of you probably have seen on television and movies, you know, where you get the person under the lamp and you deprive them of food and water until you get them to ultimately confess to an offense. And there are many examples throughout the country where individuals have actually entered a confession for killing someone when they actually did not do so. And one of the cases that we took a look at was a case out of New Orleans, a gentleman who was accused of killing a child who was interrogated for about 9.5 hours and ultimately confessed when he did not commit the offense. And the thing that's interesting, that they, again, deprived him essentially of food and water for that period of time, wore him down. He confessed immediately upon them allowing him to get some rest. He recanted his confession. Unfortunately, he remained on death row for many years until he ultimately was exonerated for DNA. But what was interesting about that, he was interrogated for 9.5 hours. He was videotaped for about 1.5 hours. And so one of the recommendations that we made is that any custodial interrogation must be videotaped. And if it's not videotaped, what we wanted to say was that it couldn't be used, but what we ended up doing was saying that if it's not videotaped, then it is presumed to be not admissible. And what's interesting, I mean, a lot of the debate was, well, you know, some police agencies don't have it. Some police agencies may be difficult to do so. And one of the examples that I use, I had a trial where an individual was interrogated and there was not a videotape. In Columbus, pretty much all of the interrogations now, regardless of the type of case, is videotaped. But I completed a trial in which a person was not videotaped. And one of the jurors at the conclusion of the trial, when we had a chance to talk, said, well, why didn't the officer just pull out his cell phone? And the thing is, the technology exists. And so that an interview or an interrogation can occur without it being videotaped in this day and age. I mean, there's very little reason that I can think of. So the very first recommendation that we made was that all interrogations must be videotaped in capital cases, and if they're not, then that interrogation is presumed to be involuntary, that it was forced. And what we found, some of the statistics that I found were that of the, I think so there were 104 wrongful homicide convictions that were overturned by DNA evidence. It says in 64 of those cases, or 62% of those cases, there were actually false confessions. So persons who confessed, convicted of murder, but fortunately were exonerated when DNA evidence was found to show that there was someone else. And it said that 30 of the 64 pled to crimes that they did not commit at all. So that's one of the reasons why we think that all interrogations need to be videotaped. And that's the recommendation that we're hoping that the legislature will pass. Another one of our recommendations is that all labs need to be accredited. Again, when you're talking about the preservation of evidence, when you're talking about a lab linking an individual to a crime, and yet you're saying that the lab itself is not accredited by any of the national organizations, again, the debate was, well, why not? Why shouldn't a lab that's making a report and sending information that is potentially being used to place someone on death row, why is that information or that evidence not from an accredited lab? So our recommendation was that the testing of evidence needs to be done in an accredited lab. And if it were not done in an accredited lab, then a person that's been accused can request that the evidence, and we're obviously essentially talking more so DNA evidence than anything else, have the right, or blood evidence, have the right to have that information or that evidence tested in an accredited lab. Then another one of our recommendations, at least that I think kind of go to the heart of what we were trying to do, and this is an interesting one, and I would love to, when we get to the questioning part of this, kind of get some of your thoughts on this. One of the real problems with prosecuting death penalty cases is the cost. And we're not talking about the cost after someone is convicted. I mean, the cost after someone convicted is huge. But actually the cost of trying a capital case can run up to $80,000 to $100,000 when you're talking about the cost for the defense, cost of experts. Well, a lot of counties aren't willing to foot those expenses, or a lot of counties are willing to prosecute someone on a capital case on the cheap. In other words, paying defense attorneys minimal amounts of money, not willing to pay defense attorneys for the cost of experts or psychiatric reports, or, as I indicated earlier, people with mental illnesses actually being prosecuted and convicted of capital cases. And so we actually recommended a capital fund so that money could be pulled from one centralized fund for this purpose. Now, there's a double-edged sword to that. If funding is made available, obviously, then the potential for more counties willing to do this could increase. But the flip side is, if the charge of our committee was to look at the death penalty in Ohio and figure out ways to make it fair, then one of the most fair ways to do so was ensuring that if a person is charged with a capital offense, that the funding for defense attorneys, the funding for experts, the funding for psychological evaluations and things of that sort need to take place. And so that's one of the reasons why we ultimately decided. Because if you look around the state, there were a couple of counties that actually indicated in their paperwork that they were willing to pay up to $5,000 on a capital case. Okay, which, you know, that doesn't get anything accomplished with that amount. But the highest amount in Ohio was some counties willing to pay up to $75,000 for the cost of prosecution. But because of the fact that there have been so many situations where defense counsel have not been competent, because again, you're not going to get a lot of the better attorneys doing it because of the time that's necessary to handle these cases if you're not going to be willing to pay them and then afford them the money that they need to put forth a viable defense. I mean, I don't know how familiar most of you are with the process of a capital case, but generally speaking, if a person is convicted in a capital case, there's a second phase, the penalty phase. It's at the penalty phase that a defense attorney can bring forth to the jury information to consider about the childhood of the individual, the schooling of the individual, if the individual has had any kind of psychiatric treatment. They're bringing in all of this information so that it can get in front of the jury for them to make a determination as to whether it outbalances putting the person to death. Well, part of the problem is that in many counties, the money necessary to get those types of experts to testify was not afforded to the defendant. And that's where you end up with individuals with mental illnesses sitting on death row. Let me hit one more recommendation, and then I just want to kind of give you a quick summary of some of the other things that we did. One of the recommendations that we made that created the most fervor, I guess, from at least the prosecutors. There was a recommendation placed on the table for a vote to do away with what's called felony murder. The way the law exists in Ohio, if me and another person commit a crime, we decide that we're going to rob a bank. In the course of robbing that bank, if someone is shot and killed, you can be charged, both of them can be charged with murder, whether I pulled the trigger or not. My co-defendant was the one that pulled the trigger, even though it wasn't my intention to cause the death of any person. In Ohio, the law is that both of us could be charged with murder. And the way the law exists, both of us could be charged with aggravated murder with capital specs. So our recommendation was to do away with that. And part of the reason for that is because it places a lot of discretion on the prosecutor in terms of the types of cases. Throughout this process, we kept saying, look, if we're going to have the death penalty in Ohio, then it should be reserved for the worst of the worst. And a person should not be sitting on death row because, again, they decided to rob a bank, and unfortunately, during the course of that occurring, someone died. And so, again, the disparity around the state, a lot of statistics that we took a look at indicated, again, that ethnic minorities were the ones that tended to get prosecuted the most often under the felony murder statutes in Ohio, and they were disproportionately impacted by that. And by removing it out as a category of cases that could be considered for capital punishment, what we were essentially doing was, to some degree, balancing it and ensuring that more ethnic minorities were not just being prosecuted for the capital cases in situations in which others were not. But there was it was another situation where after we made the recommendation, the only thing that was in the paper the next day was that we were trying to get rid of the death penalty in Ohio by limiting the number of cases, the types of cases. So my takeaway from our task force was what we really were attempting to do, and well, let me back up just a little bit. There were no agendas when we started this, believe me. There were not individuals coming to the table with the purpose, sole purpose of just getting rid of the death penalty. And so that they were trying to create legislation to do so. Because when we completed our report, the minority report said that the purpose of our recommendations was to get rid of the death penalty in Ohio. And it's that statement that's caused the Dispatch and others to vote against or to editorialize against the work that we did, because they're saying that the work that we did was solely for the purpose of trying to get rid of the death penalty in Ohio. What we, I think, accomplished was, one, limiting the types of cases in which the death penalty would be eligible for. And also, what we were trying to do, and I think we accomplished with our recommendation, was making sure that any person that gets charged with a capital offense, that the evidence that is being used against them, that the quality of evidence has to be higher and better than you would have in any other case, which is, again, why we're pushing for the certified labs. And finally, with one of our recommendations one of our recommendations was for a centralized body to make the decisions about filing capital cases. And our recommendation was that there would be a group of former prosecutors and attorney generals that would get together and make those decisions, as opposed to individual prosecutors in individual counties. And one of the reasons that recommendation was done, so that we don't have a situation like we have in Cuyahoga, or had in Cuyahoga County, because there's a new county prosecutor. He's taking a totally different approach to it, where one county is filing twice as many capital indictments than the rest of the state. And by centralizing that process, what we're hoping to ensure is that individual, and I hate to use the term, but it's my word, a rogue prosecutor is not out there just indicting everyone that they potentially can, when there's many situations and circumstances when the death penalty should not be placed on the table as a potential sentence. So, like I said, a little over 2 years, 55 recommendations. There's no way that I can go through all of them, but what I'm hoping is just enough information here to kind of give you a flavor for what it is that we're hoping. And if the legislature were willing to take this up, and that's going to be a big if, but if they're willing to take it up, like I said, what I think we'll see ultimately is fewer capital indictments in Ohio, and better representation for those who do get charged with capital cases, keeping people with mental illness out of that process as well, and ensuring that the quality of evidence is such that we don't have people in the midst of interrogations admitting to committing crimes that they didn't do, and having the quality of evidence that if they actually did do it, that we are convicting the right person. Because, as we all know, I mean, there's been sufficient findings with DNA around the country that persons have been exonerated at a fairly high level based upon DNA evidence. And we know for a fact that individuals have been on death row and have been exonerated with DNA evidence as well. And so our goal is to ensure that those type of individuals don't end up there. And I know we're going to take questions at the end, and I think I had about 10 or 15 minutes. So thank you for your attention.